From your calendar, AMCON conference call starts in 30 minutes. From your calendar, AMCON conference call starts in 30 minutes.
Hello, welcome to the July 19th, 2023 version of The Bullet. My name is Paul Lathrop. I am the Deputy Director of New Media for the Second Amendment Foundation. As we get going today, I want to remind you, if you're watching us on the Facebook or YouTube channels for the Polite Society podcast, to go ahead and comment on the live video. We'll get your comments, we'll get them up on the air, and we'll discuss them as we're live. Computer's running better today. Did some more work on it last night, so everything should go without a hitch today. Today is going to be a little bit of a shorter program. At the top of the hour, I have to do a conference call for the AMCON event coming up in September in Phoenix. The planning committee is doing a conference call tonight, and rather than reschedule the conference call, I decided to shoot the bullet live a half an hour early. I hope you all got the notification in enough time that you can tune in, and let's go ahead and get started. First thing I've got is a press release from the Citizens Committee for the Right to Keep and Bear Arms. I'm just going to go ahead and read a little bit of this. This one kind of caught me by a little bit by surprise because I hadn't heard it yet, but Alan had, and so anyway, here we go. The Citizens Committee for the Right to Keep and Bear Arms is calling out anti-gun Democrat Congressman Jamie Raskin of Maryland for portraying Hunter Biden as a rich guy exercising his Second Amendment rights as an explanation for Biden's purchase of a handgun while allegedly failing to admit his drug use on the federal Form 4473 he filled out. I'm not sure whether to shake my head in disgust or just laugh out loud, said CCR-KBA Chairman Alan Gottlieb. I'm going to go ahead and continue with a quote from Alan. Raskin's flippant dismissal of what would otherwise be a serious criminal act if anybody other than Hunter Biden were involved is either a new low in attempted sarcasm or an exhibition of monumental stupidity. I'm going to say probably the latter myself. President Biden's son last month agreed to enter a plea on reduced drug charges and cut a deal regarding the admitted firearms violation, requiring him to stay out of trouble for at least 2 years. He will thereby retain his Second Amendment rights, where other citizens who enter false information on a Form 4473 would face felony charges, prison, and lose their gun rights. And this is another quote from Alan. Jamie Raskin needs to understand it's something about federal gun laws. Typical rich guys exercising their Second Amendment rights don't get stoned on drugs before they go shopping. Rich guys buying guns don't lie on a 4473 and expect to get away with it. Rich guys, and even poor guys, don't get special treatment from federal prosecutors regarding gun-related crimes unless their last name is Biden and their dad is president. The Hunter Biden case is a deplorable example of dual standard justice, Gottlieb said. If someone else got this level of preferential treatment on a gun law violation, Raskin and his fellow Democrats would be howling about it. And they know it. Raskin never met a restrictive gun control law he didn't immediately love until the law could be used to put a Biden behind bars. Then, all of a sudden, the Maryland congressman tries to portray the allegations against Hunter Biden to be an attack on the Second Amendment. The hypocrisy, he says, is staggering. I agree wholeheartedly with Alan Gottlieb. This situation with Biden, if it were, and when this broke, I made the analogy, if this were Hunter Trump or Hunter DeSantis, he would be under the jail. And Raskin would be calling for his immediate execution before trial. It's simply because he's trying to suck up to Papa Joe. Yeah, ridiculousness. Let me get this one up. This is from John Alinsky, and he says, Democrats are hypocrites. Well, yeah. In other words, John, in other news, John, water's wet. Next story, California Rifle and Pistol Association needs your help. Got this right from their website. On Monday, CRPA attorneys appeared in San Diego U.S. District Court at the request of District Court Judge Benitez to answer questions about the appropriate next steps in CRPA's Road versus Bonta lawsuit challenging ammunition sales restriction laws that were put in effect by Gavin Newsom's Prop 63. CRP already got a win in this case when the court properly applied the reasoning in the Supreme Court's 2008 Heller decision and granted CRPA's request for an injunction blocking enforcement of the ammo sales restrictions several years ago. But that injunction was stayed in the Ninth Circuit when the state appealed the loss, and then the Ninth Circuit sent the case back down to Judge Benitez to reconsider his ruling in light of the Bruin decision issued by the Supreme Court in June of 2022. Since the Bruin decision clarified and established a test that is even tougher for the state to pass, the Heller decision was we expect to win again, but the road case is still at the preliminary injunction phase, so San Diego court is pushing the case to final judgment. Assuming CRPA prevails again, the state's lawyers will no doubt appeal again. At the court hearing, the state's lawyer told Judge Benitez to allow the state 30 days to submit more declarations from supposed experts on the history of background checks and why this new law is historically justified, as the Bruin test requires. So far, they haven't been able to do so, and the judge expressed skepticism that the state could produce anything new. But the court nonetheless gave the state 30 days to submit its new evidence. CRPA's legal team will also have a chance to submit their own additional declarations showing what an ongoing disaster California's ammunition licensing scheme is and to respond to any declarations the state files. This is where we need your help, they write. The state does not dispute that California's unworkable ammunition purchasing laws have stopped thousands of people who are legally eligible to buy ammunition from buying it. But amazingly, the state is now arguing the case should not move forward because CRPA does not have legal standing to challenge the law because its members have not themselves encountered these problems. And that's nonsense, of course, but to assist CRPA in demonstrating how the law continues to block eligible people, particularly CRPA members, from buying ammunition, CRPA needs declarations from members and supporters evidencing any problems you have recently faced when trying to buy ammunition. To make sure we don't get sidetracked on this legal issue, it's important you reach out to CRPA's lawyers if you have a history of hardship under California's ammunition sales laws. Contact attorney Costas Moros at KMOROS at michellawyers.com. That's MICHELLAWYERS.com right away to share your story. And I'm going to go ahead and I'm going to get the link for this, and I'm copying it right now as we speak. I'm going to go over to the comments for both YouTube and Facebook, And I just popped that into the comments section. And if you are a California resident and you've had issues buying ammunition, look at that story, get that email address, and email Costas Moros. Let him know the problems you've had. They need examples of people who are in California who've had problems buying ammunition for this to go forward. I wish it were Legal Friday with Alex Uli. That doesn't come up for 6 days. Excuse me. No, he's not even. We're going to be this coming Friday is Training Friday, and then Legal Friday, the Friday following that, we're not going to have a show. I'm going to be traveling to Detroit. Alex Uli will be on with me that Saturday night from Detroit, but I'm not in a position where I can ask him, but he could easily explain what standing meant in relation to this California case. I simply cannot, other than they're saying that that California Rifle and Pistol Association does not have the ability to sue because they are not directly affected by the law. And their members are saying are not being affected by the law. So if you live in California, get in touch with Costas Moros and make sure he knows that you are having problems getting ammunition and specifically what those problems are. All right. I want to get this up. Going back to our previous story. Warsaw Patriot says Republicans also be not pro 2A. Yeah, that is not a exclusive domain of the left. I mean, there are people on the right who can, and Republicans who can and are occasionally anti-rights. I'm thinking of the at the time governor, now senator from Florida, Rick Scott, who signed the ban for 18 to 20-year-olds to buy long guns in Florida. That was not a great move. There are a lot more examples of anti-gun Republicans. Let's go all the way back to St. Ronald Reagan. We got a horrible piece of gun control legislation when in the form of the Firearms Owners Protection Act of 1986. That was some good, but it also gave us no, you cannot purchase a new machine gun manufactured after 1986, although I could be wrong, and it could have been 84. But anyway, you could that's where you cannot purchase a new machine gun was from the Firearms Owners Protection Act. Before that, you could purchase anything you wanted. You just had to buy a $200 tax stamp. Let's see here. CNT Designs and Arms. Thank you, buddy. Let me get this comment up here. Standing means you have to be in legal jeopardy. I think in this, and I don't mean to disagree with you, CNT. You're probably right. You're probably closer to base on this one than I am. I think, however, standing means legal, that you are affected. Not that you are in legal jeopardy, that you are affected by this law. And, yeah, I think, let's see here. Oh, let me get two more in, or a few more comments in from Warsaw Patriot. I've also seen Democrats who see themselves moderates and help support Republicans against the far left in our right for the Second Amendment. He follows up with, look at Manchin and Sinema, two great examples of Democrats who are not necessarily our enemies. If it weren't for Manchin and Sinema, there's some stuff that may have made it through the Senate this year. He also adds, We also lost the filibuster. We almost lost the filibuster if it wasn't for both of them. And CNT says it confirms that Reagan was horrible when it came to guns, and yes, it was the '86 Firearms Owners Protection Act. So yeah, let me go ahead because we're already 14 minutes in, and I've got more stories that I want to get to. Oklahoma resident denied carry permit because of marijuana card. Mark Bertolet, a longtime concealed firearm permit holder in Oklahoma, found his application for renewal rejected due to his medical marijuana card. Bertolet, who uses medical marijuana to manage neuropathy side effects, was surprised by this outcome, particularly given the state's Second Amendment sanctuary status established by Senate Bill 631 in 2021. This law promises to protect ownership's rights for all law-abiding citizens. Another law, Senate Bill 959, was supposed to protect the gun rights of medical marijuana patients specifically. However, Bertolet still faced denial. According to the Oklahoma State Bureau of Investigation, which oversees firearm permits, they must prioritize federal laws and guidelines above state ones. This creates a conflict as federal law still classifies marijuana as a Schedule I controlled substance, a category that includes substances like heroin and cocaine, and I might add fentanyl. Bertolet argued that his Second Amendment rights are being violated, prompting him to contact State Senator Nathan Dahm and U.S. Senator Mark Wayne Mullen for assistance. In Oklahoma, we are blessed because our legislators saw fit to make it a Second Amendment state, and I've been assured that I can still carry and no one will harass me, Bertolet said. Well, I would say he can still carry inside Oklahoma. Oklahoma is a constitutional carry state. He could have, as a matter of fact, he could carry from Oklahoma, and starting this September, he could drive all the way north to the Canada border and all the way south to the Mexico border, and he'd be just fine. Because all those states, Texas, Oklahoma, Kansas, starting in September, and I'm not sure if it's September or October, but starting this fall, Nebraska, South Dakota, and North Dakota are all permitless carry states. There are a few states that still do reciprocity with Oklahoma that he may not be able to carry in without an Oklahoma permit. I want to get two more stories in here. They're related, and then I'll get back to comments. First one. This is a story. Where are we at? Here we go. In 1988, Congress passed a bill banning undetectable firearms. We talked about this a little bit yesterday. The Undetectable Firearms Act was a response to Glock releasing a polymer pistol. Now, the Undetectable Firearms Act is back and might be up for reauthorization, hidden in the National Defense Authorization Act, the NDAA. Glock polymer gun design was the first polymer pistol that saw widespread adoption in the country. Anti-gun groups started to spread the propaganda about Glocks not being detectable by metal detectors, even though those accusations were and remain false. It made it into movies such as Die Hard 2, where John McClane stated the terrorist group was using Glock 7s and could sneak by airport metal detectors. Not only did the movie writers promote the misinformation, so did members of Congress. The politicians were so scared that they rushed through a bill banning non-existent firearms. In truth, all guns were detectable at the time, including the dreaded Glocks. Only the frame was made of polymer. The slide, barrel, firing pin, and many other parts were and are still produced using metal. Also, the brass, lead, or copper in ammunition itself would set off metal detectors. The bill demanded minimum amounts of metal in firearms. It was due to sunset in 2013, but Congress reauthorized it. So in 2013, because in 2013, no gun became close to being undetectable. Now there are attempts to sneak it into the NDAA, and this time Congress is trying for a permanent reauthorization. I'm going to skip down here. Senator Jack Reed out of Rhode Island is busy working with Republicans behind the scenes in the Senate to get the bill's reauthorization attached to NDAA, and it looks like it might have some bipartisan support. Senator Chuck Schumer called for a vote on cloture Monday night at 5:30 p.m. Eastern Time. The vote will limit the debate to 30 hours. After the clock runs out, Senate could vote on the amendment. Since the NDAA in the House of Representatives will conflict with the Senate version, the two sides will hold a conference to work out the differences. Both chambers will still have to pass a reconciled NDAA. Now, while we're talking about the NDAA, here's some things Senator Chris Murphy has put into NDAA, and I got this off of Mark Oliva's story on Amalan. These are just proposals that he's made. Senator Murphy's proposals would require training before anyone in the Department of Defense purchases a firearm for private ownership. It would also require anyone possessing a firearm on a military installation to register that firearm with the base commander, require that the firearm be locked in the home, and all ammunition stored separately. It would also require privately owned firearms to be registered with base authorities. That would include firearms legally purchased off base and never brought on the base. That's problematic. A base commander has the authority to prescribe regulations within the fence, but that authority ends at the front gate. Another amendment from Murphy would unnecessarily delay rights to service members. He wants to force a federal 7-day waiting period for the purchase of any firearm and a 4-day waiting period for the purchases of ammunition. After that, the Senator's NDAA amendment would allow the Defense Secretary to collect all gun owner information for both military and civilian employees about the lawful possession, ownership, carrying, or other use of privately owned firearm or ammunition, if such information is necessary for the purposes of injury and mortality prevention. Finally, another amendment prohibits the possession of privately owned firearms that are not related to performance of official duties on property of the department by anyone who does not live on the property of the department. So if you are a soldier and you live off base and you want to get your firearm and go on base to go hunting, where there's a lot of military bases that have hunting reserves on or attached to them, you can no longer do that. Yeah, let me go over here to wow, we have got all kinds of comments in here. Let me see here. Let me get some of the comments. And I'm sorry, I'm trying to read through them as quickly. You know what? Yeah, I'm going to go back to the Oklahoma story and get this one in from CNT. It's a case of something being legal in a state, but these gun control laws are federal. You know, and they keep making noise on the federal level. I don't know if they're ever going to get it done. They keep making noise in the federal level of removing marijuana from it being a Schedule 1 drug. We'll have to see if that happens. We're sticking strictly to gun rights here. My personal belief, whatever you want to put in your body, that's your business as long as it doesn't affect somebody else. So I'm not going to get into whether marijuana is harmful, whether it's helpful. There's a lot of states where it's not against state laws anymore. You can still, a federal marshal can still arrest you for possession of marijuana. You get this in from CNT. I'm going to the story we just finished up here. I hunt on Fort Benning, now Fort Moore, with my dad. You have to register any firearms you bring on base. Well, if Murphy gets his way, if Senator Chris Murphy gets his way, you can't register them and bring them on base anymore. Unless it's vital to duties on the base, you just can't bring it in, period, registered or not. That's what's in this NDAA. What I'm going to suggest to everybody, and we're getting down towards we're getting up towards the top of the hour. Podcast listeners, forgive me. You could be any time when you listen to this, but we're getting to close to the time I got, so we're going to leave the stories there. I got more stories I'm going to get to tomorrow, including one from Missouri, and we'll get to that tomorrow. But I'm going to encourage everybody, give your Congress critters, both Congress critters and senators, a call. I used to have a button I could push and put the number up on the screen, but and I used to have the number memorized. Okay, I'm trying to Google, and I'm trying to get my brain to work, and it's not working so well. I wish DJ Plain Ice were watching. He'd already have it up for me. There we go. There it is. The number you want to call is 202 area code and then 225-3121. That is the Capitol U.S. Capitol switchboard. And you can get a hold of both of your senators and your Congress critter from there. All you got to know is your zip code. If you know your zip code, they know who represents you. And yeah, I don't see DJ in the comments. I do see CNT Designs put up a comment. DJ Plain Ice is the man. He is, man. The guy is a wealth of knowledge and super supportive of those he's involved with. But anyway, again, that number 202-225-3121, and they can get you in touch. And I would strongly encourage you to get in touch with your elected representatives. Tell them you don't want anything like this in the National Defense Authorization Act. Remember, back in the Obama administration, through the National Defense Authorization Act, we got national park carry. Before the Obama administration, national parks were off limits while carrying concealed. That ended through the National Defense Authorization Act. So, and this was, and again, so I'm rambling on too much, and time is running away from me, and I've got to start the process of getting out of here. So, everybody, thank you for watching. Please do tune in tomorrow. I've got more news I did not have time to get to today. And until then, everybody, we'll see you next time.